know what you're thinking. My name is on it, so it's mine. I'm not so fast. I'll show you exactly what counts as marital property, what counts as separate property, and the one thing that turns separate property into marital property almost instantly. I'm Gray Ellis, founder and managing partner of Ellis Family Law. Nearly 20 years, our firm has helped thousands of families across North Carolina protect what matters most through some of life's toughest transitions. If you're facing a high conflict divorce or custody dispute, give us a call at Ellis Family Law, 919-688-9400. A marital property is all real and personal property acquired by either spouse during the marriage and before the date of separation that was acquired in any way other than a gift from a third party to just one of you or an inheritance to just one of you. Key phrase here is acquired during the marriage. You acquired it while you were married and before you separated, generally it's marital property. Here's the part that surprises most people. It doesn't matter whose name it's in. If you bought a car during the marriage and only your name is on the title, it's still marital property. If you earned income deposited into your personal account during the marriage, it's still marital property. Why? Because North Carolina law views marriage as an economic partnership. Both spouses contribute to building the marital estate, whether through income, homemaking, child rearing, or supporting the other spouse's career. So property acquired during that partnership belongs to both spouses, regardless of whose name is on the title. What does marital property include? It includes real estate, vehicles, boats, bank accounts, investment accounts, stocks, and bonds. Retirement accounts like 401ks, IRAs, and pensions. Business interests that were acquired or grew during the marriage. Personal property like furniture, jewelry, art, and collectibles. Income earned during the marriage. And yes, even marital debt on credit cards and loans taken out during the marriage can be marital obligations that get divided. Now, there's one critical date you need to understand: the date of separation. Marital property includes everything acquired from the date of marriage to the date of separation, with the exception of third-party gifts and inheritances. Once you separate, property you acquire after that point is generally separate property, depending on the source of funds used to acquire it. Income you earn after separation is also typically your separate property. This is why documenting your date of separation clearly is so important. It stops the marital property clock. So that's marital property. What is separate property? Separate property is property that belongs to one spouse only and does not get divided in divorce. There are three categories of separate property in North Carolina. Category 1, property owned before your marriage. Anything you own before you got married stays yours. If you bought a house before marriage, that house is your separate property. Car you own, a savings account you had, a retirement account balance as of the date of marriage, all separate property. But here's what most people miss. Only the premarital portion is separate. Any growth, added appreciation, or contributions during the marriage may be marital property. Category 2, gifts and inheritances. Property received as a gift or inheritance during the marriage is your separate property. Critical requirement here is that the gift or inheritance must have been given specifically to you, not to both spouses jointly. If your parents leave you money in your will, that's your separate property. If your grandmother gives you her jewelry, that's separate. If your uncle gives you a car for your birthday, that's separate. Category 3, property acquired after date of separation. Once you separate, income you earn after separation is separate property. So property you buy with post-separation income is separate. This is another reason why the date of separation is so critical. It marks the end of the economic partnership and the beginning of your separate financial lives. One interesting note, professional licenses and degrees are not considered property in North Carolina. Your law degree, your medical license, or your MBA is not something that can get divided. Here's where it gets complicated and where most people lose separate property without even realizing it. The commingling trap. Commingling is when you mix separate property with marital property. If you do this, your separate property can become marital property. This is one of the most common and most costly mistakes in divorce. Think of separate property and marital property like two different colored paints. As long as you can keep them separate cans, you can clearly identify which is which. But the moment you pour them together and mix them, you may not be able to separate them anymore. So how do you protect your separate property? Keep separate property separate. Don't deposit inheritances or gifts into joint accounts. Open a separate account in your name only for separate property. Don't use marital income to pay for or improve separate property, or if you do, document it very carefully so you can prove what's marital and what's separate. Keep clear records showing the source and nature of separate property. The simplest rule is this: keep separate property completely separate from anything marital. Document everything. Keep bank statements showing your account balances before you got married. Keep closing documents from property you purchased before marriage. Keep letters, wills, or other documentation showing that property was a gift or inheritance given specifically to you. Take screenshots or get statements showing your retirement account balances as of your date of marriage. Why is this important? Because the burden of proof is on you to show that property is separate. If you can't prove it, you lose it. Consider a prenuptial agreement or a post. A prenuptial agreement signed before marriage can clearly define what stays separate and what becomes marital. Postnuptial agreements signed during the marriage can do the same. These agreements can protect separate property, prevent future disputes, and give you clarity and peace of mind, but they must be done correctly with full financial disclosure from both spouses. Otherwise, they can be challenged and potentially thrown out. Also of note, North Carolina does not require each party to have an attorney for the document to be enforceable. However, one attorney cannot represent you both in preparing these documents, even if you're in full agreement. Get expert legal help. Property classification is one of the most technical and complex areas of family law. If you have a significant separate property, you need an attorney who understands tracing, commingling, and valuation. Mistakes in this area can cost you for decades. Don't try to handle it yourself. Bottom line is this. Just because you think property is yours doesn't make it separate property under North Carolina law. Just because your name is on something doesn't mean it won't be divided. Understanding these rules and protecting yourself from the beginning is absolutely critical. If you're facing a divorce in North Carolina, give us a call at Ellis Family Law, 919-688-9400 to schedule a consultation. At Ellis Family Law, we've helped thousands of clients in the Triangle area protect their separate property and get through complex property division cases. Our board-certified specialists know how to trace separate property, value assets, and present your case strategically to protect what's rightfully yours. And if you're not sure whether you're ready to file for divorce yet, or you want to know what steps you need to take before you file to protect yourself, watch this next video where I'll walk you through the 5 critical things you must do before filing in North Carolina.